You might have missed it among all the 14th Amendment talk this week, but things down in the Mar-a-Lago classified documents case have been very busy. One of the many filings this week was a scathing response from special counsel Jack Smith to a request made by Trump's lawyers for more time for pretrial discovery. Now, if the judge in this case grants Trump's request, it would delay the scheduled May 20th trial even longer than it already seems to be delayed. As special counsel Smith wrote, Trump's objective is plain: to delay the trial as long as possible. And the tactics they deploy are relentless and misleading. They will stop at nothing to stall the adjudication of the charges against them by a fair and impartial jury of citizens. Smith continues, their motive is additionally revealed by the nature of one of the motions that the defendant now suggests they intend to file, a motion to dismiss based on purported presidential immunity, despite the fact that the criminal conduct charged in the superseding indictment took place entirely after defendant Trump left office. Joining me now is Joyce Vance, former U.S. attorney in the Northern District of Alabama and professor at the University of Alabama School of Law. Joyce, thank you for being here. I feel like for a long time, Jack Smith has been quite restrained, at least in the writing of a lot of these filings. This one, however, really seems to reveal a man frustrated. Who do you think is the audience for this particular file? Is it Judge Cannon, or is it maybe the 11th Circuit Court of Appeals?
You know, Judge Cannon is the audience for, I think, Jack Smith's increasing outrage this week. It's in this motion. It's in a squabble over potentially releasing the names of witnesses. Federal prosecutors are very measured, and there's always someone to read your motion before you file it. That was my job for a long time as the appellate chief in my office. And something that I did was I made sure that not even a hint of discourtesy crept into our pleadings when we filed them in front of a federal judge. So you know that for this strident of a tone to be used in a variety of motions, it's a deliberate strategical decision. They are putting her on notice, in essence, that she's crossed the line and that they won't tolerate the commission of clear error.
I mean, it's not the only filing that the special counsel's office has made this week. He also is saying plainly that he thinks Judge Cannon made a, quote, clear error in her order to unseal, I believe it's redacted discovery documents. The special counsel's office has said, you know, effectively releasing these documents would expose witnesses and it would trigger intimidations and threats against, again, not just witnesses, but even Judge Cannon herself. In the course of that, we learn that there is an ongoing separate federal investigation into witness intimidation or threats made against a prospective government witness. So it seems like there's real currency to the argument Jack Smith is making here in his plea to Judge Cannon. And yet, Joyce, do you think this is going to fall on deaf ears?
So it's an interesting question, Alex. I mean, we're super nerdy in the weeds here in terms of talking about these sorts of pleadings, about discovery. This is the sort of stuff that doesn't usually happen in a case because most judges are very concerned about the safety of witnesses. And at the first whiff of potential threat to a witness, most judges will take every step necessary to protect those folks. That's not what's happening here. And so Jack Smith has, as you say, accused Judge Cannon of committing clear error. That's the standard he has to allege in this sort of a technical motion for her to reconsider one of her earlier rulings. And he's right. She has committed clear error, requiring him to prove stuff that he doesn't have to prove. But the most important thing to know about this is that he is clearly outraged that she would expose witnesses and that she would expose information about an ongoing federal investigation to Donald Trump. She has now ordered him to turn that over. You know, I had not expected things to come to a head in this case until she ruled on the Classified Information Procedures Act hearing she's holding next week. But Jack Smith may be on track to go to the 11th Circuit earlier than that. I say maybe cautiously, but it's possible that they would file a motion called a writ of mandamus asking the 11th Circuit to order her to protect these witnesses' identities from disclosure rather than run the risk that they be exposed to harm.
Yeah, can we just talk about that? Because that is the breaking kind of news this hour, if you will, that Judge Cannon is effectively ignoring the special counsel's pleas, the concerns that he's voiced about witnesses under threat or intimidation, and is saying the court finds an insufficient basis provided to deviate from the sort of traditional adversarial process in this instance, which is to say these documents need to be shared with Trump's counsel. Sorry, Jack Smith. I mean, does that seem unusual to you?
I don't think unusual even begins to capture it. It's really extraordinary. Prosecutors have to be able to protect witnesses, not just in this case, but in every case, because we ask people to come forward to tell the truth so we can hold criminals accountable. And sometimes criminals aren't super nice people. In this case, we've got a defendant who, whether through his fault or through the implications his followers take from his comments, witnesses, people who have spoken out against him, have been exposed to risk. And in some cases, Speaker Pelosi's husband, Paul, comes to mind, exposed to harm because his wife had become one of Trump's political targets. So look, if you're a federal judge, what you're doing here is you're listening to prosecutors, you're carefully evaluating the evidence and the law, and when they come to you saying this is so serious that we have an ongoing investigation that we need to protect, you don't then turn that over to Donald Trump, the defendant.
Well, it seems like there is a case to be made, whether now or in the future, about whether Judge Cannon is the right judge for this case. But that all remains TBD. Joyce Vance, thank you, my friend, as always, for sharing this Friday night with me. At age 81, Joe Biden is the oldest sitting president in American history. And Biden has addressed this fact in two different ways. He has adopted a sort of youthful anti-hero alter ego, Dark Brandon. That started as a meme on the far right, Biden with those red laser eyes. But the president has come to embrace it. We have since seen Biden drinking coffee from a Dark Brandon mug. His campaign sells Dark Brandon stickers and T-shirts and baseball caps and tumblers. And if you happen to click on a broken link on the Biden campaign website, you won't see that usual 404 error. You will see Dark Brandon. The other way President Biden has addressed his age is by really playing up his seniority. In November, Biden posted to Instagram a photo of his birthday cake in flames. He wrote, "Thanks for the birthday well wishes today, everyone. Turns out on your 146th birthday, you run out of space for candles." Last April, he shared a few zingers at the White House Correspondents' Dinner.
After all, I believe in the First Amendment, not just because my good friend Jimmy Madison wrote it. Call me old. I call it being seasoned. You say I'm ancient. I say I'm wise. You say I'm over the hill. Don Lemon would say that's a man in his prime.
Now, the latest national NBC News poll shows that 76% of voters are concerned about President Biden's age. On Wednesday, I asked former presidential candidate Hillary Clinton about this fact and how Biden should handle it. The X factor in all of this, the thing that we keep seeing in poll after poll after poll is concern about Biden's age. Mm-hmm. Full stop. Mm-hmm. What should he do on this? Is it a matter of sort of like underscoring his boundless energy, mm-hmm. or should he embrace his 8 decades on Earth and the great wisdom he's gained through all of this?
I mean, do you have
all of the above?
All of the above. I mean, I talk to people in the White House all the time, and they know it's an issue. But as I like to say, look, it's a legitimate issue. It's a legitimate issue for Trump, who's only 3 years younger, right? So it's an issue. Once you say that, then you have to also talk about what's at stake in the election, and I'm for Joe Biden for re-election on the merits, because I think he's done a really good job as president. So I think he should continue to get out and campaign. He's been campaigning pretty vigorously across the country, and he actually does events where he's interacting with people, unlike Trump, who stands on a stage and, goes on for 90 minutes. Biden's taking questions. He's talking to people in small
Not from the
groups.
media.
Well, but that's okay. And, it's okay. I'm sorry, Alex. It's okay.
We respectfully disagree.
Neither is Trump. I mean, neither one of them are going. They at this point in the campaign are trying to, communicate with as many people as possible. I think Biden also should lean in to the fact that he's experienced. And that experience is not just in the political arena. It's like the stuff of, human experience.
Yeah,
Character, wisdom. I think he should be willing to really hold that out. Say, how do you pull together a coalition to stand against Russian aggression? Well, you don't do it by photo ops. You do it because you have long experience in dealing with leaders and you know what's at stake. And I think he should kid more about it. He sometimes makes a joke when, we haven't done something like this since, James Madison, and I talked to him about it. I mean, I think things like that, which are sort of
I just
funny.
turned 113 years old.
Yeah, exactly.
It is hereby ordered, adjudged, and decreed that after a jury trial before the Honorable Louis A. Kaplan, plaintiff E. Jean Carroll has judgment for damages against the defendant Donald J. Trump for an aggregate sum of $83,300,000. That order is essentially a bill. Donald Trump must pay the $83.3 million he owes to E. Jean Carroll immediately. It does not matter that Donald Trump is appealing this case. It does not matter that Donald Trump is running for president. It does not matter that Donald Trump believes he had a good day at the Supreme Court yesterday. The law is binding, and Donald Trump must either fork over the money or pony up some collateral to someone who will fork over the money for him. Now, this order from Judge Kaplan is an important reminder that while Trump may have breathed a sigh of relief at the Supreme Court yesterday, there is still a lot of legal peril on the horizon for him, the very near horizon, like next week. Recall that at the beginning of this week, a D.C. appeals court thoroughly and unanimously rejected Trump's claim that he has presidential immunity and he cannot be prosecuted for trying to overturn the 2020 election. Now, that federal election interference case against Trump has effectively been put on ice while this presidential immunity issue works its way through the courts. But Trump has until Monday to tell the Supreme Court whether he plans to appeal. And whether or not the court decides to keep this case frozen after Monday to essentially make time for Trump's appeal could tell us a whole lot about whether this court is sympathetic to Mr. Trump or whether this court is quite the opposite. Many legal experts here believe that the win the court is about to hand Donald Trump in the 14th Amendment case may be offset by a potential rejection in his bid for immunity in the election interference case. As Professor Richard Hassan writes for Slate, a grand bargain that appears to make practical sense as a compromise is beginning to come into view. The Supreme Court unanimously holds that Colorado does not have the power to remove Donald Trump from its ballot. But in a separate case, it rejects his immunity argument and makes Trump go on trial this spring or summer on federal election subversion charges. So it's a big moment in which we may know whether the Supreme Court is inclined to let the federal criminal trial go forward before the November election. But that's not it. And it's not the only case where Donald Trump is relying on so-called presidential immunity to shield him from accountability. There is also the civil lawsuit brought by Capitol Police officers who were trying to hold Trump civilly liable for the violence they faced on January 6th. Trump's lawyers have until Thursday to ask the Supreme Court to weigh in on that case as well. And Thursday is also the day that Trump's lawyers are due in a Manhattan courtroom for a pretrial hearing in Trump's criminal case involving hush money paid to an adult film actress, Stormy Daniels. That hearing could be where we learn when that case will go to trial. And then there is Trump's New York civil fraud case, the one where he could be forced to pay hundreds of millions of dollars and liquidate the Trump Organization in New York. We are still awaiting Judge Arthur Engoron's verdict in that case, which could come any day now, very possibly next week. Now, arguments in that case finished about a month ago, but that's not stopped Trump's lawyers from getting into all kinds of fights with the judge in this case as he weighs his ruling. At present, Judge Engoron is concerned that one of the top financial executives in the Trump Organization committed perjury, or at least that's the reporting. So Judge Engoron wrote to Trump's lawyers asking them for any information about that executive and his potential perjury. It seems germane to a case involving Trump's financial dealings. And Trump's lawyers sent Judge Engoron a scathing response. A response calling the judge's request for information unprecedented, inappropriate, and troubling. Well, yesterday, Judge Engoron fired back. When I sent my straightforward, narrow request for information, I was not seeking to initiate a wide-ranging debate with counsel. However, your misleading response grossly mischaracterizes the letter that I wrote, and I feel compelled to respond. You and your co-counsel have been questioning my impartiality since the early days of this case, presumably because I sometimes rule against your clients. That whole approach is getting old. It really seems like Trump's lawyers are going maybe out of their way to anger this judge who is about to decide whether or not to dissolve Trump's entire business in the state and make him cough up as much as maybe $370 million. And these lawyers are doing it at a time when several of Trump's other cases, civil and criminal, might be about to start moving forward. It's all a very interesting strategy. But hey, at least Trump will probably still get to run for president in the state of Colorado. Joining me now is George Conway, a conservative lawyer and contributor to The Atlantic. Also with me is Rick Hasen, UCLA professor, director of the Safeguarding Democracy Project, and author of the upcoming book, A Real Right to Vote. Professor Hasen, let me just start with you. I know both of you all have very important, essential reads today and in the last week. I'd love, Professor, if you could talk a little bit more about the grand bargain you see developing and what it portends for this potential presidential immunity appeal from Donald Trump.
Well, it's kind of a fortuity for Jack Smith, the special counsel, that the immunity case is arriving at the Supreme Court right as the court is deciding what to do in the disqualification case. You may remember that Jack Smith went months ago to the Supreme Court, tried to leapfrog the Court of Appeals, get the court to rule on this. The whole ballgame is timing. Now it seems like with a majority of justices, both liberal and conservative, seeming to side with Trump in the disqualification case, you could see that there could be a lot of pressure on the other side to say, let's let this case go to trial, the case on election subversion in Washington, D.C. So Trump wins one, he gets to stay on the ballot, but he loses a big one. He goes on trial this spring or summer for election subversion in Washington, D.C., thereby letting the voters decide whether or not Trump is really disqualified from serving for office.
Can I just follow on that, Professor, just because when we hear the term grand bargain, we usually think of congressional negotiations or legislative negotiations. Is it now sort of just accepted that the Supreme Court is so clearly letting politics, or at least political perceptions, intervene or at least inform the decisions they're making in big pieces of litigation?
Well, I don't think they're actually going to be bargaining and saying, I'll vote this way if you vote that way. But I think that there's a kind of tacit agreements in these kinds of things, and how much pushback, say, the liberal justices are going to give in the disqualification case. Remember, you've got 6 Republican-appointed justices. You've got 3 Democratic-appointed justices. It's not going to be a good look for the Supreme Court if it's a 6-3 decision. I don't think that's likely to be. But if Justices Kagan and Jackson, at least, are willing to go along here, then, you know, it takes 5 votes to put a stay in place in that immunity case. It takes only 4 to have a hearing. The justices have got to know that all the eyes are on them, and it's going to look a lot less lopsided if the court gives with one hand and takes from the other, even if they're not engaged in the kind of horse trading that you might see on the floor of the House of Representatives.
Right, not quite. Well, there's not as many horses to be traded, shall we say.